Okay, everyone, we've finally gotten to the point of drafting simple contracts. This is one of my favorite chapters because it has some really practical tips on clauses you can put in your contracts. The book points out that you want to start with a thorough understanding of the precise wishes of the contracting parties. This may not always be clear. Parties may sometimes be confused, deliberately ambiguous. They may be trying to head off what they think may be a disagreement by simply glossing over it. That's something you have to be very delicate with when you deal with drafting a contract. When you start, you should definitely have a checklist of clauses or topics that needs to be covered, and you're going to use Chapter 12 as that checklist for your drafting contract experience in this class. Definitely don't reinvent the wheel from scratch. Definitely use prior materials, but you have to carefully scrutinize them to make sure they actually fit the situation. Let's look at this checklist of clauses. Number one, a contract should have a description of the parties. They need to be precise, full, exact legal names of the entities or individuals involved. There's something called nomenclature. Nomenclature is an official shorthand that you use once you've used the full name once in the description of the parties. You shorten that name maybe to a person's last name or to a corporation's primary name, and then the key is that you use that shorthand description throughout the contract consistently. The same process of nomenclature is used in pleadings as it is in contracts. It's a very important concept because once you get the shorthand correct and you use it consistently, everybody can count on you using it in the same way. So don't leave this class without the concept of nomenclature, which is essentially a shorthand used consistently throughout. Description of the consideration on page 292. The idea behind this is if you list the consideration that's being exchanged, you give a basis for somebody to challenge the contract if that consideration is not provided. Description of the consideration gives you an understanding of what is expected that the parties will exchange, and that can be grounds for suit if those are not exchanged properly. Security agreement. This is just the concept of somebody funding a purchase and the funder retaining a hook in that purchase. Your basic repo man, somebody who has a right to take the car back because you haven't paid the payments on it. So a security agreement is whenever somebody has a bit of security in something else, that collateral for the loan. Warranties. We will discuss those when we get We will discuss warranties when we get to Chapter 8. As the book says, under the Uniform Commercial Code, certain warranties are either implied or expressed in every contract, and they should be specified therein. Putting a warranty in a contract gives a right to sue in case there's a breach of that warranty. So it makes clear the party's rights in the event of a failure of the contract. Title on page 295 is a legal concept that basically means somebody owns the right to possess and owns full legal ownership of the item. In some contracts there's a delay in when title is transferred, and that needs to be specified when that occurs. Risk of loss is a concept that says who has the risk of loss when something is in transit. At what point does that risk transfer to the buyer rather than the seller? We'll discuss that in more detail later, but it should definitely be specified if you're selling a good in a contract. This waiver provision on page 296 is very important. Every one of your contracts should include some form of a waiver provision that basically says, the first example on page 296 is what you might call a no oral mod clause, and what that means is there can be no oral modifications to the contract. As it specifies, you need to have a written agreement to vary or modify the contract, and that prevents problems with casually spoken words outside of a contract situation, like maybe buying a used car or something like that. The other kind of waiver provision says, just because I let you slide once doesn't mean you'll slide forever. In other words, if I'm a landlord and I waive the right to timely payment 1 month, that doesn't mean I waive it forever. Because in the absence of a clause like that, you're the landlord waiving 1 month of timely payment a court could construe that as a waiver of the timely payment provision. Assignability we'll talk about in more detail later, but basically you need to discuss whether the rights and benefits and the duties under the contract can be given to somebody else to perform or to receive. So you have to think about that. If you're in a rental agreement, do you want the tenant to be able to sublet it to somebody else and thereby assign their rights to live in the place and their duty of payment to somebody else? And that's a complicated question. Most people don't allow that, but it boils down to whether the contract is assignable. So in the standard lingo, we say that rights are assigned, duties are delegated, as described on page 297 and 296. You might want to open your book, if it's not open already, to 298, because I'm going to discuss the special provisions and clauses listed there. If you are hiring an employee, you might consider a covenant not to compete clause. Those are very popular. They have limits. Courts have said that covenants not to compete will not typically be allowed to extend beyond 2 years, and they typically can't go geographically beyond what is needed for the employer. If either of those two conditions are met, a covenant not to compete may be stricken, and the court may what we call blue pencil it. By that they mean they just change the contract to wipe out the covenant not to compete. So as an employer, you always want to make sure that these covenants are not overbroad or overlong. Regarding employee duties, you can imagine why it would be helpful to specify the duties. That determines the consideration and what is assumed to be the starting point between the employer and the employee, and it gives the employee a bit of an argument that more pay should accompany more duties at a later point. Pronouns is obvious. You can figure out what that means. Now severability. Every one of your contracts should contain a severability clause in it. What it means essentially is if the court strikes any small provision or any portion of that contract down, the contract survives. You want to have a severability clause just in case, for example, you have an overly broad covenant not to compete and the court strikes that down. You don't want them to assume the whole contract is gone. For successors, the issue is, let's say corporate changes. Let's say Apple buys a small company and that small company's contracts. The question is, can Apple be a successor to the small company because there's a corporate change in corporate status? So that's a typical clause for changes in corporate status. Time is of the essence. That is a key clause that you want in any contract where time is in fact of the essence. In other words, where time is important. In a real estate contract, for example, there are frequently these clauses, and what they mean is, hey, the backdrop behind our contract is that we are expecting you to move quickly. If you do not move quickly, you may have breached this clause. Now, a real estate contract is going to have specified days as to when things need to be done. But this time is of the essence clause is like a backup clause that says, and the whole context of this contract is that you've got to move swiftly. So if the person fails to meet those deadlines, or if they fail to move swiftly, the court can say the party is breaching that clause and therefore have breached their entire obligation under the contract. Trade secrets is obvious. You use that when you have something you don't want the employee to share. Work product, that just specifies who owns various intellectual property rights that arise during the employment relationship. Duration and termination. When parties contract, they're often very happy, even giddy, that a relationship is being formed, and they don't always think about the end results. As my mama, who's been married 7 times, says, you got to think about your exit strategy. You have to think about how the contract's going to end. And you want to make clear the process for communicating about a default. So if somebody has breached the agreement, how do you tell them that they have? There should be some process, such as, upon breach of this contract, the party aggrieved may send a letter via certified mail to so-and-so. This is obviously more appropriate in more complex contracts, maybe a Hughes aircraft via Qualcomm kind of situation. But it's still useful to know what the process is when things break down. Remedies. Oh my gosh, we clearly need to think about what happens if the thing breaks down. What are the remedies? What can the party do in the event of a breach? And obviously you have to be creative here. And if the UCC applies, there's a whole set of remedies that would apply. And the UCC applies to the sale of goods, not services. So in a service contract, you may have to make up your remedies more than you would if it's under the UCC. Choice of law. This is one of my favorite clauses. It's an opportunity to ask the court to use a different state law as a backdrop for the contract dispute. So you can actually specify, as many of your MasterCard agreements do, that the choice of law will be, say, North Dakota or South Dakota, and then that means that a court would have to consider South Dakota law to make its decision about who breached. Did you know that courts have the power and the obligation to apply a different state law than the very state law that's sitting in front of them? Yes, that is true. 2 parties, especially contractual parties, can choose any state or any local or any government that they wish to use to insert as a choice of law. Maybe they're all familiar with Delaware law because that's where they're incorporated. They can specify the contract is governed by Delaware even though it's formed in California and both parties are from California. You do not have to have a relationship to the state to justify asking the court to apply that state's law to the contractual dispute. Arbitration. Arbitration is a little bit on the wane. It's very expensive. It's essentially private litigation where you pay for the judges as opposed to having a judge paid for by the public dollar. But a lot of companies want arbitration because it means people will probably not sue because arbitration lacks the jackpot factor that sometimes occurs with juries, say in Mississippi and Tennessee and Florida and places like that. So arbitration takes risk out of the hands of usually the party providing the money or the seller. So that's why they put those clauses in to avoid the who knows what factor of a jury. Submission to jurisdiction. This is different than choice of law. Choice of law says, hey, Washington court, you need to apply Oregon law to this dispute. Submission to jurisdiction says, hey, Washington court, the parties to this contract have agreed in advance that they will be submitted to the jurisdiction of your court, even though they're in Florida. So the Florida parties agree that they will have to walk physically into a Washington court to resolve their dispute, even though the Washington court may not otherwise have had the power over them because they're not regularly connected to the state. But because the parties have submitted to jurisdiction in advance, they are compelled to go to that state for resolution of their problems. And don't forget the signatures. Okay, I'm at 14 minutes and I'm on slide 7. What that tells me is I need to leave the rest of the materials for you to read on the slides. They're explainable. You can actually read the slides and understand them. So please read the slides for the rest of the material for tips on drafting.